The choices you're about to make shape how the rest of your will and several other documents in this package will come together. A will is a set of instructions that tells the court who should receive your property and who should be in charge after your death. It also names guardians for minor children if that applies to you. What a will doesn't do is control assets that already pass outside of probate, like beneficiary designated accounts, jointly owned property with survivorship rights, or certain transfer on death arrangements. That's why this package works as a system, not a single document in isolation. The will you're creating here follows a very intentional structure. It starts by identifying you and your family relationships, then moves into how property should be handled, who's responsible for carrying out your wishes, and what happens if circumstances change. You don't need to understand every legal clause, that's our job. What you need to focus on is answering the questions accurately and thoughtfully, because those answers ripple through the entire package. Some of the questions you're seeing now affect later documents, like powers of attorney, medical directives, and how authority is assigned. Think of this like a blueprint. If the foundation is right, everything else fits better together the way that it should. Now, if you're married or were previously married, you may see references to community property. At a very high level, community property refers to assets acquired during a marriage that are legally considered owned by both spouses. What matters here is accurately reflecting your current marital status and understanding that some property rights exist by law, regardless of what a will says. Finally, accuracy matters. Not perfection, but accuracy. Names, relationships, and basic facts should be correct. If something truly doesn't apply, choose the option that best fits and keep moving forward. Take your time with this section. Once these foundational choices are set, the rest of the process tends to feel much smoother. And remember, if questions come up that feel bigger than the form, that's exactly when a consultation can help.
If you'd like a Nevada attorney to review your documents or your situation, you can schedule a consultation for $250. Using this form and watching this video does not create an attorney-client relationship. This content is educational only.